2019 Civil Test 2. 1. Appeals from Nassau District or any district court go to the appellate term of the Supreme Court. 2. Appeals from family court go to the appellate division. So same as like Supreme Court appeals or surrogates court appeals, go to the appellate division. 3. In deciding a special proceeding, a summary determination shall be made on the papers, admissions, and pleadings to the extent no triable issues of fact be raised. 4. In a special proceeding where there is no adverse party, the petition shall state what? Now, this is just asking for not all the information in a petition, which is like grounds for a leave, whatever. This is just saying what additional information do we want to see in the petition when there's no adverse party? And the answer was 2, 3, and 4, but not 1, so D. If the relief prayed for has been previously requested, so that's kind of understood in this, because you have to put the result of any application for similar relief. Specifically, the new facts, if any, that were not previously known. So you need all that stuff, in addition to what has to be in the regular petition. 5. In a special proceeding, the proper times for service of the notice and petition, together with the petition, answer, and reply, are 1271 and 820. So remember, don't get mixed up. 1671 and 820, that's a motion, not a special proceeding. And the 830 is when you have a cross motion. So when someone serves you a motion and you want to serve a cross motion, you have to give them that extra day. So it's 830. But otherwise, it's 1271, 820 for a special proceeding and 1671, 820 for a motion. 6. A court's decision determining the rights of a party to a special proceeding is called a judgment, just like in a regular action. 7. The party who commences a special proceeding is styled the petitioner and the adverse party the respondent. One note about this, so in a regular action it's plaintiff defendant, and in appeals it's appellant respondent. So special proceeding you have petitioner respondent, just like in family courts. In appeals, it's appellant and respondent, and the appellant is whoever brings the appeal. Doesn't matter who they were in the original action. And then in a regular action, plaintiff, defendant. 9. In a special proceeding, an adverse party may raise an objection to a point of law there's 2 ways they can raise an objection to a point of law. It's setting it forth in their answer, or making a motion to dismiss on notice within the time allowed to answer. So the answer is D, 1 or 2 only. 10. In a special proceeding, the party bringing the proceeding, so the petitioner, may raise an objection to a point of law and now 1 is wrong because it says to dismiss. If it said making a motion to strike, that would have been okay. But it's setting it forth in their reply, that's true, and moving a strike matter on the date the petition is noticed or re-noticed to be heard. So the answer was 2 and 3, only C. 11. If triable issues of fact are raised in a special proceeding, they shall be tried forthwith. Okay, so if issues of fact are raised, they are not severed, they're not adjourned, they're supposed to be tried forthwith. 12. A notice of petition shall specify the time and place of the hearing and the supporting affidavits, if any, which accompany the petition. So answer was A, 1, 2, and 5. 13. In a special proceeding, a notice of petition shall be served in the same manner as a summons. And please note that a subpoena, when you serve a subpoena on a non-party, that is also served in the same manner as a summons. When a person who should join an action as a plaintiff refuses to do so, he may be made a defendant. And if you're unable to serve him, then that's non-joinder. So that could be a problem. 1003, number 15. Which, if any, are grounds for dismissal of an action with prejudice? And the answer is D, none of the above. Because none of this stuff is with prejudice. It's without prejudice. So if it said without prejudice, the answer would have been B, non-joinder. You have to read fucking carefully. This is a practice question of my dad's that I actually got wrong when I took the practice test because I didn't read it carefully and I didn't see, oh shit, it says with prejudice. Prejudice, just in case you want to know what that means, when an action is dismissed with prejudice, that means you cannot bring it back again. You can't go and sue the person again because they can come back and say, excuse me, Your Honor, I say res judicata, this judge already dismissed this with prejudice. Without prejudice means you just have to start over, but you can bring the action again. 16, true or false? And this is true. Parties may be dropped by the court on motion of any party or sua sponte at any stage of the action and upon terms as may be just. So parties can be dropped on the court's own initiative or on motion at any stage of the action. That's the key there. And that the court can drop them on its own. 17. A stakeholder is a person who is or may be exposed to multiple liability as a result of adverse claims, and such person may commence an action of interpleader. A claimant is a person who has made or may be expected to make such a claim. So, for example, let's say Karen and Barbara are going to buy a car. They, for some reason, buy a car together. And they buy the car from Sean. And then they get into a fight and both of them are saying, give me the car. Now, Sean doesn't know what to do because he's like, well, I know this car is not mine, but I don't want to get sued by Karen if I give it to Barbara. And I don't want to get sued by Barbara if I give it to Karen. So I'm going to commence an action of interpleader against both Karen and Barbara and ask the court to basically take this car and put it in escrow. And then the court can figure out which one of them actually gets it. But I know I'm not entitled to it, so I really don't want to deal with this. So I'm going to commence an action of interpleader. I'm the stakeholder, Sean is the stakeholder, against Karen and Barbara, and they're the claimants. So now let's read this question. 17. A stakeholder is a person who is or may be exposed to multiple liability as a result of adverse claims, and such person may commence an action of interpleader. A claimant is a person who has made or may be expected to make such a claim. 18. This is true. The court may order any claim against any party severed and proceeded with separately. 19. When may a defendant proceed against the person not a party who is or may be liable to that defendant for all or part of the plaintiff's claim? And the answer is after service of the answer. So first you serve your fucking answer, then you worry about who else you're going to sue. So I'll give you a scenario what third-party practice actually looks like. So Miranda is the original plaintiff. Miranda commences an action. She sues Heather. Now Heather says, okay, yes, I understand, Miranda, you're owed this money, but not by me. You're owed this money by Jasmine. She's the one who really caused you to lose this money. So I'm going to bring her into the action by serving a third-party summons and complaint on Jasmine. Now, Jasmine is known as the third-party defendant. Miranda is always the plaintiff. But Heather now has two names. Heather is both the original defendant, so Heather's the defendant. She's also the third-party plaintiff. So that's how that works. And she has to serve her answer on Miranda first. Then she can go proceed against Jasmine by serving a third-party summons and complaint on Jasmine. And at the same time that she serves her third-party summons and complaint on Jasmine, she also has to serve the original complaint that was served on her, but not the summons because she doesn't need another invitation to court. So she gets Jasmine is going to get served 3 documents by Heather. She's got to get served the third-party summons, the third-party complaint, and the original complaint. 20. This is true. A third-party defendant may assert any defense against the plaintiff except the defense that the original summons wasn't properly served. And remember, a third-party plaintiff is also the original defendant. So now, what is this saying here? So let's say there's Jasmine gets her third-party complaint. She reads it, and she's like, this is fucking bullshit. I'm raising all these defenses. The one defense she cannot raise is that Miranda blew the service on Heather. Heather's got to raise that defense. Jasmine can't raise it for her. That's all that's saying.